Today's topic of discussion is equality and social justice. The Constitution of India begins with the preamble whose opening words are, "We the people of India." It secures justice, social, economic, political, as well as equality of status and of opportunity. Equality of status and of opportunity is indispensable in order to secure justice, social, economic, and political. This goal of justice, social, economic, political is sought to be achieved through the various provisions of the Constitution of India. The right to equality is contained within Articles 14 to Article 18 of the Constitution of India. Article 14 also contains what is known as the rule of law. The term was coined by Sir Edward Coke, but it was popularized by Professor Dicey. The three ingredients of the concept of rule of law are absence of arbitrary power or supremacy of law, equality of law, and constitution being the result of ordinary law of the land. This concept of equality before law is borrowed in the Indian Constitution from English law, whereas equal protection of laws is borrowed from the American Constitution. Right to equality is within Articles 14 to Article 18. 14 is the genus which contains equality before law and equal protection of laws. Article 15 prohibits discrimination on grounds of religion, race, caste, sex, or place of birth. Article 16 provides equality of opportunity in matters of public employment. Article 17 provides abolition of untouchability. Article 18 provides abolition of titles. Article 14 contains that the state shall not deny to any person equality before law and equal protection of laws. Equality before law is a negative concept and implies no special privilege to individuals, whereas equal protection of law is a positive concept which connotes equal treatment. Any person, the term any person used in Article 14 implies that this right is available both to citizen as well as non-citizen. It is available even to a foreigner or even to artificial juridical persons. What do you mean by equality in Article 14? Equality doesn't mean absolute equality, which is not possible. Equality in Article 14 envisages equals must be treated equally. As Dr. Jennings puts it, equality before the law means that among equals, the law should be equal and should be equally administered, that like should be treated alike. Equal protection of laws to be interpreted to mean subjection to equal law, applicable to all in the same circumstances, that like should be treated alike and not unlike to be treated alike. It does not mean all laws must be of general character. Rather, it necessitates reasonable classification. Article 14 forbids class legislation, but it allows classification which is a reasonable classification. Now, the Supreme Court of India evolved this doctrine of reasonable classification through various judicial pronouncements. The landmark cases in which this reasonable classification was used was Chiranjit Lal Chaudhary versus Union of India, 1950. State of West Bengal versus Anwar Ali Sarkar, 1952. Ramakrishna Dalmia versus Justice Tendolkar, 1958. E.P. Royappa versus State of Tamil Nadu, 1974. Now, let us try and understand what is the meaning of reasonable classification. We all know Article 13 lays down that laws which violate any of the fundamental rights under Part 3 are void and are unconstitutional. So, if any law is shown to violate any of the provisions of Part 3, that law will be declared ultra vires. But if a law is sought to be declared ultra vires the Constitution on the ground that it is violative of Article 14, the Supreme Court of India evolved this test of reasonable classification in order to test whether the law is really violative of Article 14 or not. Now, let us come to the discussion of what are the ingredients of this theory of reasonable classification. In order to test a law on the touchstone of this doctrine of reasonable classification, the apex court laid down that first one has to see whether the class which this law seeks to prefer, do they have any reason, any intelligible differentia. Intelligible differentia means any characteristic, any trait in them which distinguishes them from the rest of the society, and whether the law has a rational nexus with this differentia with the object to be sought by this act. If both the answers are in the affirmative, then the law passes the test of reasonable classification and is not violative of Article 14 of the Constitution of India. In Chiranjit Lal Chaudhary versus Union of India, the Supreme Court declared that even a single person may constitute a class. In State of West Bengal versus Anwar Ali Sarkar, the Supreme Court declared certain special courts laws to be ultra vires the Constitution because the arbitrary power was bestowed on the government to decide which cases will come under the special courts. So, where an act is arbitrary, it is implicit in it that it is unequal both according to political logic and constitutional law, and is therefore violative of Article 14, as Justice Bhagwati puts it. The various judicial pronouncements which are landmark in the history of Article 14, that is right to equality, are R.D. Sethi versus Airport Authority, Air India versus Nargis Mirza. This case dealt with the discrimination meted out to women employees of Air India. Randhir Singh versus Union of India, Mithu versus State of Punjab, which is a very famous case in which we know that section 303 of the Indian Penal Code was declared unconstitutional as being violative of Article 14 of the Constitution of India. K. Nagraj versus State of Andhra Pradesh, Saira Banu versus Union of India is a recent case in which triple talaq was declared unconstitutional. Indian Young Lawyers Association versus State of Kerala is the Sabrimala case. Navtej Singh Johar versus Union of India is the case relating to the LGBT community. Now let us come to Article 15 of the Constitution of India. No discrimination on the ground of religion, race, caste, sex or place of birth. The reservation policy, which is a tool to ensure social justice is founded on Article 14, Article 15, Article 16 and Article 38, which is a directive in Part 4 of the Constitution of India, the Directive Principles of State Policy. Social justice as a concept consists of diverse principles for the orderly growth and development of personality of every citizen, as laid down in Air India Statutory Corporation versus United Labour's Union. Reservation is a way to achieve practicable equity, not fantastic equality. Reservation or reverse discrimination or protective discrimination, as it is called in other legal systems like US, is necessary in order to undo the discrimination meted out for generations to certain sections of a stratified society like India, which were socially and educationally backward classes of citizens, economically weaker sections, women and specially abled people. Reservation in the educational institutions are dealt with in Article 15.4, 15.5 and 15.6. Reservation in public employment is dealt with in Article 16.4 and 16.6. These clauses in the articles are enabling clauses, meaning if the state enacts any law providing reservation to the marginalized sections, then these laws will be validated by the enabling clauses as laid down in 15.4 and 16.4. Now let us throw some light on the types of reservation. Reservation can be categorized into two types. One is the horizontal for women and specially abled people, and two, the vertical provided for the scheduled castes, scheduled tribes and OBCs. Does reservation policy violate right to equality? As was explained earlier, Article 14 envisages equality in equal circumstances and not equality in unequal circumstances. So, the stratified society as India is or had been, if we have equality amongst unequals, it will lead to more inequality. So, the provisions relating to equality all the more reinforces the need for reservation in a caste-ridden stratified society like India. Provision for reservation is an exception which does not nullify the main provisions. Protective discrimination is the basis of reservation. Basis of determining backward classes is also laid down in the various pronouncements of the court. The historic decision of the Mandal Commission case, that is providing reservation to the other backward classes, in the landmark decision of Indira Sawhney versus Union of India, decided in the year 1993. Now, backward class of citizens in Article 16.4 can be determined or identified on the basis of caste and not only on economic basis. So, the very basis of OBCs, as was decided by the court in Indira Sawhney, is caste and economic condition was not the basis. Article 16.4 is an instance of classification for public employment. Backward classes in Article 16 clause 4 are not similar to socially and educationally backward classes in Article 15.4. Let us try and distinguish between Article 15.4 and Article 16.4. 15.4 is an enabling clause to ensure reservation to the vulnerable classes in general, but Article 16.4 ensures reservation to the marginalized classes in public employment or in government jobs. The Indira Sawhney judgment has something unique. It creates a provision for exclusion of the creamy layer from backward classes. Now, what is this creamy layer? creamy layer is that class of people amongst the backward class which, after availing of reservation for a few generations, have developed a little and they no more need the reservation. If this creamy layer is not scraped off, we create less backward and more backward within the same backward classes. So, it was a welcome step by the Supreme Court of India in Indira Sawhney in laying down the provision that creamy layer is to be excluded from the backward classes. Reservation shall not exceed 50% was another provision, another direction made by the Supreme Court in this case. A backward class of citizen cannot be identified only and exclusively with reference to the economic criteria. This was also laid down in Indira Sawhney's case. No reservation in promotions was a dictum of the apex court in Indira Sawhney versus Union of India. However, later on it was overruled in later cases. Reservation for economically weaker sections. This is a new era which has come into vogue by virtue of the 103rd Constitutional Amendment Act 2019, as is popularly known as 10% quota for EWS, the economically weaker sections. However, this was challenged in a case Janhit Abhiyan versus Union of India by a writ petition, and the grounds of challenge were: reservation cannot be based solely on economic criteria as was set forth in Indira Sawhney's case. So, this was one of the grounds of challenge. The scheduled castes, scheduled tribes and OBCs cannot be excluded from economic reservations, as this would violate the fundamental right to equality. As I already explained, equality before law and equal circumstances, equal protection of laws, that is equality in equal circumstances, that envisages reservation. So, this was also a ground of challenge in this Janhit Abhiyan versus Union of India. Another ground of challenge was the amendment introduces reservations that exceed the 50% ceiling limit on reservation. But the Supreme Court recently upheld the 103rd Amendment, Constitutional Amendment in Janhit Abhiyan versus Union of India by a majority of 3:2. Now, let us go through briefly the various milestones laid down by the Supreme Court in the development of the jurisprudence of reservation or productive discrimination under the Constitution of India. The first case was the State of Madras versus Champakam Dorai Rajan. In this case, law providing for reservation in government jobs was declared unconstitutional by the Supreme Court, which necessitated the First Amendment Act to the Constitution of India, which brought in 15(4) and 16(4). The next important landmark case was Balaji versus State of Mysore, where this 50% ceiling limit of reservation was laid down by the Supreme Court. Next is Indira Sawhney versus Union of India, which is reservations for the other backward classes. The next case, M. Nagaraj versus Union of India, it validated certain amendments to the Constitution of India which introduced reservation in promotion, which was turned down by the Supreme Court in Indira Sawhney, was overruled by M. Nagaraj versus Union of India. The next important reservation case was Jarnail Singh versus Lakshmi Narayan Gupta in 2018, and the final Janhit Abhiyan versus Union of India, which validated the 103rd Amendment to the Constitution of India on the basis of economic criteria, is or was decided by the Supreme Court in 2022. We have secured ourselves justice, social, economic and political in the preamble to the Constitution of India. and also equality of status and of opportunity. Let us try and understand what is the meaning of social justice. In a stratified society like India, where we still have a rigid caste system, equality and equal circumstances can only ensure social justice. Now, what do one mean by equality in equal circumstances? Let us try and understand with the help of an example. Say two persons are asked to run 100 meters. Now, say person A is asked to start from this and person B is asked to start from this starting line. And if both of them are asked to run 100 meters, don't you think that this already existing gap between the two will keep on increasing? This is exactly what happens in a country like India. Say a person who belongs to the scheduled tribe, say Santhal, Kol, Bhil, Munda, who had been leading a life of marginalization, of manual labor for centuries, and say any other community who are a city dweller or a town dweller. If the children of both these two persons, they apply for a government job, don't you think that a person who is the child of that Santhal, he is in a disadvantaged position, and in this position, if the law is equal for both of them, it will increase the inequity or inequality existing between these two persons in the society. So what does the law do? The law ought to provide some reservation, some protective discrimination to the child of the Santhal, so that he can be brought at par with the rest of the society. But how long this is to continue and how that is to be done, the modalities, they are laid down in the constitution and in the various laws. But then this rule of social justice have often been used as a tool of politicking. That is another issue. But then the Constitution of India and the constitutional law of various other countries, they have this provision of reverse discrimination, protective discrimination, by which we ensure that victims of discrimination, marginalization for centuries, they are given their due by the state in order to make them, or in order that they avail the fruits of prosperity the nation is ensuring to all sections of the society. And hence we have these enabling clauses in the form of 15(4) and 16(4) in the Constitution of India. In the first case, Champakam Dorai Rajan, the court declared a law providing for reservation on the basis of caste. Why? Because we did not have any provision in the Constitution of India which will justify such a law on the basis of equality in equal circumstances. And since there was no provision, that law came in conflict with Article 14, and according to Article 13, any law which is violative of any of the provisions of Part 3 of the Constitution shall be declared ultra vires and void, and hence the law was declared void. And then the necessity of the first amendment to the Constitution of India arose, and Article 15(4) was inserted in order to enable laws providing for reservation or protective discrimination for the marginalized sections, for the backward people, for the scheduled castes, scheduled tribes. Later on, it was decided by the lawmakers that we also need reservation for the other backward classes. Not only the scheduled caste, scheduled tribes, but we need reservation for the other backward classes. And for that, a commission was appointed named Mandal Commission, which submitted its report. The report was actually tabled and it was in the cold storage, but again due to political compulsions, the then Prime Minister VP Singh, he implemented the Mandal Commission report in order to provide reservations to the other backward classes, which was challenged in the Supreme Court in the case of Indira Sawhney versus Union of India, where the Supreme Court upheld the reservation provided to the other backward classes. But then in that case, this creamy layer concept was introduced, which according to some jurists, some political thinkers, is a necessity in certain cases of SC/STs also. But then that is a subject of debate yet to be decided by the court. It also declared that total reservations should not exceed 50%, which was later on overruled, and reservation in promotions was also ensured, because the apex court felt that in order to give full justice or proper justice to the marginalized sections of the society, we need reservation in promotions also. Thank you.